next case on this morning's docket. That is case number 116650, State of Kansas v. Elgin Robinson, Jr.
Outside, not sure what we were doing next.
Trying to settle the case.
I'd have to get my client's consent on that. Your Honor, may I have 3 minutes for rebuttal?
You may.
Okay, thank you. May it please the court, Kristen Patty, appearing for appellant Elgin Robinson. You all are very familiar with Mr. Robinson's case. He was charged and convicted of capital murder, but the jury could not agree on the death penalty. So he's serving life in prison without the possibility of parole, plus 247 months for other crimes. He filed a 1507 that was denied. And then while his 1507 appeal was still pending, he started filing motions in his underlying criminal case requesting Brady Giglio information. There are a lot of motions. He's filed some that have been resolved, I believe, after I docketed this appeal, but are not subject to the notice of appeal that I docketed it with. And he and I have disagreed somewhat on just what is within the scope of this appeal. I believe another attorney has now docketed an appeal from the denial of his other motions. What he has sought in this case, in this appeal, is Brady Giglio information regarding Detective Ralph. And as I outlined in the brief, this court's opinion from his direct appeal discussed what Detective Ralph's testimony was in not only his jury trial, but also in a co-defendant's as well. In the summer of 2014, the Sedgwick County District Attorney revealed to the public that there was this Brady Giglio list. There's a list of, at that time, it was 34 law enforcement personnel who were not allowed to sign probable cause affidavits and maybe cannot testify in court because they have credibility issues. And what I think is kind of surprising is it does include some detectives, and it does include some people convicted of felonies, at least two. And whether those are detectives.
Like three detectives?
I think three detectives. And so just who this list is, I personally do not know.
And isn't that the problem with all of this? Doesn't there have to be, if you are entitled, and that's an if, and I'm not sure the mechanism in which you get there, but if you're entitled to post-conviction discovery, which maybe you can articulate that you are, but doesn't there have to be just at least some specificity here, not just a guess that, well, he could be on this list, and that's really all he's put forward. He doesn't there have to be something more here?
I would think that it would be able to be resolved fairly quickly if an attorney could be appointed to represent him in district court, whether that attorney could have access to the list, and in this case would be able to know whether A, Detective Ralph was on the list. I mean, either he is or he isn't. B, the other thing that would seem to be important was Detective Ralph on the list at the time of Mr. Robinson's trial. Or we do have a gap of 5 years here.
Right.
So, if he's done something more recent, that's not something that would have had to have been disclosed to the jury at Mr. Robinson's trial because it hadn't occurred yet.
Excuse me for interrupting, but that's not what he asked. He asked, shouldn't you have to show something on the front end, because otherwise this is just speculation. You're saying, oh, well, it wouldn't take much to end the speculation.
That's true.
I don't care about that. I want to know whether there must be some showing that there's a reason why this defendant has an interest in this controversy, other than the fact that he got convicted in Sedgwick County.
Right. And this is part of the problem, because I know of something from my letters with Mr. Robinson that he didn't put in his motion. And he's told me...
Let's get back to the...
Okay, right.
I don't care about that. I care about whether there should be a legal requirement that he show something to make a connection between himself and this controversy, other than the fact that he's a criminal defendant out of Sedgwick County.
Right.
Yes or, just should there be that, or should every criminal defendant in Sedgwick County be allowed to ask whether whether their name's on that list?
Okay.
So we need to appoint a whole bunch of lawyers to go take a look at the list.
Well, I certainly wish that he had been more specific, yes. And,
Is there a reason he loses because he didn't do that? Regardless of whether you wish there was something here, did there have to be something here?
He certainly, I know because he and I have argued, he was aware of something that he did not put in his motion. I can tell you that. Otherwise, is it just a fishing expedition? Certainly, I can see that there might be some temporal requirement of when if you make this argument 15 years after you've been convicted, maybe you shouldn't get any relief at all. He's come in a lot closer than that. I also think an important factor is the type of offense that he was convicted of, because it relates to the amount of time that he's going to be in prison.
He has chosen to use a civil statute for his avenue for remedy. Should we impose the civil discovery standards, which I'm not sure he meets here, of what must be shown before we would allow this perhaps fishless fishing expedition?
Yeah. This is the part of my argument that I thought this court would enjoy. I think that his right to discovery, or the district court's power to potentially enforce discovery, comes from the inherent powers of the court that are that come from the Kansas Constitution. And you have these inherent powers, and as long as they're not inconsistent or expressly restricted by the legislature and by statute, then it's something that a court should be able to order, because the court always has the power to, first of all, enforce the Bill of Rights, which is part of the problem, of the source of the right here.
By jumping here, and I don't mean to interrupt, Justice Lukert, are you then saying that 6237 really isn't a vehicle? Because I don't see how it is.
It isn't.
You would say that it's not.
It is not, and it's also, I would not say that it's any of the criminal discovery statutes.
So you're saying statutorily there really is no source, there is no mechanism for his relief, and really what you have left is the court's inherent power.
Exactly.
That's it.
And you love the court's inherent power, right?
Well, we exercise it when, I think what Justice Biles was asking, some sort of a showing.
Right.
So where are we on such a showing?
I think I have to concede that he did not make the showing that he could have in the filings that he made in district court that are subject to this appeal. What he has told me is
So
that...
let me clarify that. Your answer here is he hasn't given us a showing. He might have some knowledge that he could, but at this point he has not. Is that right?
I drug my heels trying to docket this appeal because he kept filing stuff that was still pending, and I was trying to get
Yeah, we
everything
appreciate
under-
that. That's why we had,
Right.
we had, we struggled with whether even to take this, how to take it, and hence the 4 questions you were asked.
Right.
And now you've answered the questions. Basically, it's inherent powers, but that is only exercised when there's some showing. It's really kind of an extreme circumstance. And you're saying there has been no showing at this point. So where do we go from here?
I mean, and didn't he also, he filed a supplemental brief and tried to get the record supplemented in this case.
By attaching an article
Yeah,
from the Wichita Eagle, and there's lots of problems with that too.
I know.
You understand? So where are we? You're acknowledging that there really has been no showing made, at least on currently what we have.
I don't believe that he made the requisite showing for this motion. I believe that he knows facts, or he thinks that he knows facts. They are at least double hearsay. And if his trial attorney would have provided him an affidavit, it would probably be in a different situation. What I would certainly at least ask this court to consider is to not, in an opinion, even if you decide to rule against him, or to not do some sort of a remand, to just even see, is Ralph on the list? And if he is on the list, is it something that would have had any bearing on, did the event occur before or after Mr. Robinson's trial?
And I appreciate you don't always, that you don't just defer to the state on these kinds of questions, that the defendant has a right to, at least if it's accessible, to look at it. But did the state make a representation that Ralph, there's just nothing to it?
They did, but part of it is can we at least double check them?
No, I understand that. Right.
It would seem to be so simple, to do, and to at least, because here's the other problem. Okay, I can certainly say, understand why no one would want the entire Brady Giglia list circulating around the Kansas prison system. And I would agree that a reasonable restriction on me as an officer of the court, if I got access to that list, that all I could tell Mr. Robinson would be, yes, Detective Ralph is on it, no, Detective Ralph is not on it. And that would be it. I couldn't send him a copy of the list. That's it. That would be, I think, beyond, unless somebody said I could do it. But I don't think that I could take that upon myself to do that. You kind of alluded a little bit to at least the article that he attached to his own supplemental pleadings. I do think that there's an opportunity here for the court to at least set some ground rules for judicial notice of media and other news reports, particularly in this internet age. I at least cited to Channel 12 and to the Wichita Eagle, which I hope are considered to be reliable news and journalism sources at this time. I didn't cite to some blog someplace. I cited to what I thought was an ethical journalism source, and I think that's also an opportunity the court has here, is to clarify the rules on citation and judicial notice of media reports. I'm almost out of time.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The issues before the court in this case stem from the defendant's pro se motion to compel discovery pursuant to 6237 and Brady-Giglio rules. The resolution of the motion centered around the claim that he should be provided Brady-Giglio concerning one of the lead detectives in his case. The state advised the district court that it was not aware of, nor was it in possession of anything related to this detective, and the court denied the motion that I can't produce what the state does not have. This court reviews for an abuse of discretion, and as set forth in our brief, it remains the state's position that that motion was properly denied. Now, subsequent to briefing in this case, this court submitted 4 additional questions that it would like the parties to address. And to the extent possible, I would like to give a short answer to each of those questions and then flesh them out. The first question, does KSA 2232-12 exclusively govern discovery in criminal cases? The state's position is yes. Did the district court have jurisdiction to consider and rule on the merits of defendant's post-conviction request for discovery? The state's position would be no. Assuming 6237 applies, what is the appropriate court in which to file the motion? The state's position would be the civil court, as his remedy is under 60-1507. Assuming the district court had jurisdiction to consider and rule on the subject motion, what is the authority for this appeal to this court? Assuming that it was properly filed in the criminal court, this court's jurisdiction would be an extension of the fact that the defendant is incarcerated on a capital murder conviction. Taking 1 and 2 together, was there jurisdiction, and does 2232-12 govern discovery in criminal cases? In a criminal case such as here, where a direct appeal has been pursued and a mandate issued, that case is final. Pursuant to that rule, the defendant's case was final as of March 26th of 2012. Subject to a few limited exceptions which are not applicable here, the defendant's case is final and the criminal court no longer has jurisdiction over the case. In Osborne, the Supreme Court noted that there's nothing in our precedents suggesting that the state's obligation to disclose Brady material prior to trial continues after defendant is convicted and the case is final. Accordingly, there is no longer any active case or controversy in defendant's criminal case under which he could have filed this motion. Second, our legislature has established and Kansas courts have reinforced that the discovery rules under the criminal code pertain to criminal cases. What rights the defendant currently possesses must be analyzed in light of the reality that he has already been afforded the constitutionally sound extensive trial to which he's entitled. There was very thorough briefing on direct appeal, an oral argument to this court, and a substantial analysis by this court. He has then had his post-conviction proceeding through 1507 and an appeal as a result of that proceeding. His access to the courts has not been restricted in any way. Turning to this court's third question, which is the proper court in which to file this motion? At this juncture, the relief that's available to the defendant is to pursue a successive 60-1507 motion and comply with those requirements. The simple fact, however, that it's a civil motion does not put him on par with civil litigants who are embarking on a trial for the first time. Supreme Court Rule 183 tells us that the civil procedure rules apply to 60-1507 to the extent that they're applicable. In a 1507 proceeding, the defendant is required to bring forth a motion of specificity. He's required to identify his claim, identify his witnesses, and identify the evidence he intends to rely on in support of his claim. By contrast, the rules of civil discovery are designed to facilitate the finding of witnesses, the discovery of evidence, the identification of evidence, the crystallization of those issues. where the basic purpose it runs counter to a 1507. That rule would not be applicable here. The defendant has already had the benefit of all of that through his criminal proceeding.
You said that his remedy is to file a 1507, but what he's seeking here is post-conviction discovery. And 1507 really isn't a mechanism for that, is it?
No, it isn't.
So there must be some way a convicted person can file for some form of discovery. Let's say there is a articulable means by which he or she could ascertain, boy, the detective who testified in my case lied, and it's been proven that he was lying through this particular period of time. We've had cases like that, and we've allowed it. What is the mechanism that someone uses?
Well, then if he has that, if he
If he
knows
has
that,
information,
then he files his 1507. There is his specificity.
How does he get it,
Newly
though?
discovered evidence.
Yeah, how does he get it?
He's not entitled to it at this point. The Supreme Court of the United States has put limitations on that and has said you look at the manner of post-conviction relief. That is not workable.
Let's use the worst possible scenario here, that Detective Ralph was somehow involved in some sort of corrupt behavior and that bled into his testimony in this case. How would he get that information? And you have knowledge of it.
Well,
how would he get that information?
First of all, I do want to clarify that the defendant has had access to this twice. There was a Brady-Giglio motion or order in place at the time of his trial.
I'm talking about
and-
later discovered. I'm talking 3 years after the fact, 5 years after.
I get it, but I just want to clarify that he has had access to this very specific information, and the state has told him twice it does not exist. There is no Brady-Giglio information with respect to Detective Ralph. So that's already been out there.
I'm using the worst case scenario. Let's say you discover it 5 years after the fact, and indeed there's some credibility to this. How does one sitting in Mr. Robinson's shoes ascertain that information?
Then if he knows and he's got the specifics, then file your 1507 motion, identify your witnesses, identify what your evidence is. That is what his relief is. That interpretation is consistent with what the Supreme Court told us in Osborne. We don't look at Brady. That's not the appropriate framework. The appropriate framework is what post-conviction relief is available to him. What is available to him at this point, after all the extensive processes he's already been through, that is the relief that's available to him. Limitations and finality are acceptable. We have put 2-year limitations on motions for new trial for newly discovered evidence. We have 1-year limitations on motions to withdraw plea, 1-year limitations on 1507s. Finality is acceptable. At some point, the criminal case must be final, and it was final when the mandate was issued in this case. Again, we look at the relief that's available to him. There was a Brady-Giglio order at the time of his trial. There was nothing available with respect to Detective Ralph. He filed this motion, and despite the fact the court didn't have jurisdiction in the state's position, the question was answered. There isn't any Brady-Giglio information with respect to Detective Ralph. If he has a specific claim, he is to pursue a 60-1507. Now, the defendant has advanced an argument with respect to judicial notice and inherent powers. That argument was not presented to the district court, and it would be the state's position, as we set forth in our brief, that it's not properly before this court for review. But even more so, it is not this court's job to pound a square peg into a round hole and come up with a form of relief for the defendant. That form of relief already exists in the form of a 60-1507 motion. The state would respectfully request that the decision of the district court be affirmed.
Do we have any further questions? Thank you, counsel.
I guess the problem with the 1507 motion is the way I feel that district courts interpret it in appellate courts when it gets him is it seems like the defendant almost has to prove his case in his motion in order to get any relief. And Justice Rosen, I think as you alluded to, and Ms. Isherwood kept saying, if he's got the specifics, how does he get the specifics? He can't, it's a catch-22 situation or a chicken and egg situation, whatever you want to say. He can't file the motion with the 1507 motion with specifics if he doesn't get this. And then they're also saying, but you can't get it if you don't file 1507.
Let me slow you down for a second here. First of all, I'd respectfully disagree that they have to prove their case in their initial pleading in a 1507. I agree that the bar is high, but it's not impossible to reach. You've repeatedly alluded today to your client being in possession of information about Detective Ralph or believing himself to be in possession of information. Why can't that be advanced in a subsequent 1507, attempting to get around the delay and the failure to raise it earlier because it's new information? Why isn't opposing counsel exactly right about the correct remedy for this? And then in that proceeding, we can cross the bridge that I believe opposing counsel attempted to walk across earlier, but it's really unnecessary to walk across today, about what further discovery might be available in the 1507 proceeding.
Right.
Why isn't that the way to proceed here? If your client has what you have suggested he thinks he has.
First of all, I apologize as far as yes, the bar is high, and I'm always telling clients, I think it's probably better to say too much in a 1507 than not say enough, and so many of them just don't say enough. If Mr. Robinson has what he says he does, then he should get an affidavit from his trial counsel, and he should, which is that he says his trial counsel told him something, and a former assistant district U.S. attorney told him, get affidavits from them, memorialize that. And, he didn't, I think regardless of whether it's filed in the criminal case or filed in a separate 1507, of course, there would be the liberal construction of pro se pleadings. It could have been considered as a pro se, as a 1507, but he wasn't as specific as he could have been when he filed his motion, and I really wish that he had been. I think he's been more specific with some other motions he's filed with other people. I would just encourage the court to, even if you ultimately decide to rule against Mr. Robinson, to not issue an opinion that would foreclose other criminal defendants. We know that we've had 3 people wrongfully convicted who've been released from Kansas prisons in the past 4 years. Sometimes it's a very, very long process.
Counsel, what are you asking us to do?
I'm asking the court, what I'd really like the court to do is, besides the judicial notice and the inherent powers, is if you ordered the district court to provide me with the Brady O'Giglio list, I promise I would not disseminate it. I would only tell Mr. Robinson what I thought he needed to know. And that would seem to put a rest to this question, if that's true.
All right. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.